Can disclaiming your inheritance put your minor children at risk? What happens essentially if you're supposed to receive an asset that has more debt than value, and clearly you don't want to receive that? If you go through a formal disclaimer, does that impact your children? There are some legal concerns here and some options to try to get around this. I'm Valerie Zammitti of Zammitti Law. We're an estate planning practice in New York and New Jersey, and we're here to educate everyone for free. We do provide peace of mind to families every day through our high client value services. If you are seeking assistance on either estate planning or the administration after the passing of a loved one, you can reach out to us for a free consultation at yourplanningattorney.com. And speaking of value, we're also here to educate everyone on a regular basis. So ask questions and please share so together we can help some folks along the way. Now, a few, legal concerns when it comes to disclaimers, right? When you disclaim assets, or more debts than assets in some cases, you are saying, I want to be treated as if I've predeceased the other person. But there's a potential that will mean that those assets and or debts are passing along down the bloodline to your own children. And if they're minors, that creates more complexity because they have to be represented by the interest of either a guardian or a conservator through the court. And, just create more nonsense and mayhem, especially if the assets really have no value or the debt exceeds the value. The minors could be left in a quirky situation, one that you obviously wouldn't want for them. So a few things. Like one, I think there's a potential to also maybe disclaim on behalf of the minors. That would have to be a petition to the court as their, guardians to do so based on the fact that there's really nothing of value there. I don't know that would be my first choice. It's a lot of steps to get to a result that you may be able to do otherwise. And I think avoiding the disclaimer altogether may reach your result if you essentially don't go forward with the process and not accepting, say, the deed to real property that's upside down, declining to participate in that formal transfer of the interest without legally disclaiming it. Eventually, at some point, those assets are going to end up in the hands of the state, or back if they're in the bank's hands, so that they can deal with it. And that just sort of helps you cut through without having to take a million steps and dealing with the court on a regular basis. If you're already in it, or if someone maybe fraudulently transferred the asset to you unwantingly, then I think you would also want to petition the court for some sort of relief, showing that it was not an asset that you were seeking, that you are not responsible for the debts, and see if they would relieve you from those assets and that legal burden. I would think so, but I have not done those processes myself. That's not really what we do, but requesting relief from the court if you're kind of already in it will be necessary. Of course, seeking assistance from an attorney of any kind to see what you can do to get out of these things is important. It's not necessarily an estate planning attorney, but it can be someone involved in estate litigation. If it deals with real property, it could be a real property attorney, foreclosure attorney, various different parties that might be able to help. So in general, right, disclaiming inheritance can accidentally put that burden onto your little kids. Nobody wants that. So if it's going to be something that you're receiving that's upside down, you may just be better off, keeping a distance, not touching it, not accepting it, and if need be, seek court court protection to distance yourself from those assets. It doesn't mean that those debts become yours, but it's just dealing with it and closing it out that becomes complicated, right? Going through the return of the property to the bank or whatever the case may be. It's just time and energy and effort that you may not want to deal with. So, and certainly shouldn't put on your minor kids. So we hope you've learned something new here today. I am Valerie Zammitti of Zammitti Law, an estate planning attorney in New York and New Jersey, and we provide peace of mind to families through our high client value services. If you do need help in the estate planning or administration arena, we can assist, and you can reach us at yourplanningattorney.com. Don't forget, please share and take care. Bye-bye.